Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Jonathan Cappy.
I'm Daniel Boucher.
Welcome to Hull on Estates. You are listening to episode number 676. Today, we are going to be discussing multiple wills. I think that, listen, we have covered multiple wills in the past between our blogs over the years, but I think that it's important to have a refresher every so often. It's something that comes up so often, and people, lawyers see it, lawyers draft it, people encounter it in their own will planning. They run into it when they are having to be an executor of someone else's will. And so I think it's important just to sort of bring this one back up to the top of the podcast list so everyone can get a sort of a quick refresher on multiple wills. So we all know what a will is, all right? And we all know that a will governs your assets and what happens with your assets when you pass away. But there's another concept where you could have more than one will that will collectively govern what happens with your assets when you pass away. Now, these wills don't have to be identical. So you can have one will which appoints one person as the executor of part of your estate and another person as an executor of another part of your estate. And generally what they're used for is where, certainly if you want different people to be executors over different assets, that's part of it. But it's also where you're trying to avoid probate over certain assets. Because generally speaking, and we're not saying this is an absolute rule, but generally speaking, there can be assets for which you don't need probate to administer. All right. So for example, the personality in your house, your couch and your TV and the things lying around your house, you don't really need a certificate of appointment of a state trustee to administer those things. So paying probate on the value of those items, particularly if you have expensive things like art in your house, may not be necessary. In terms of real estate, if you have a house that is not yet in land titles, and it can be a first transfer out into land titles, it's in the registry system, you may be able to transfer it without probate. You should certainly speak to a real estate lawyer before you make that determination. But it may be an asset for which you don't need probate, in which case you may consider having a will that deals with everything in your estate except for this piece of property, and have a separate will that just deals with this property so that you don't have to get probate for that will. Shares of privately held corporations, often you don't need probate in order to transfer them. So again, that may be another asset, which is a good use of a second will. Now you can have as many wills as you like. You can have a primary will, which generally deals with sort of everything that's not in another will. You could have a will that deals with your house. You could have a will that deals with your privately held shares. And the whole purpose of it is that you can apply, your executor can apply for probate on one or more of the wills, but not all of the wills. And when they do that, they only pay probate on the assets that fall under the wills for which probate is sought. So Daniel, why don't you start telling us about sort of the beginnings of these multiple wills and where they came from and sort of the case that started it all?
Essentially, the major case in Ontario that led to probating, or having multiple wills where only one gets subject to probate, is the case of Granovsky Estates versus Ontario. And in that case, essentially the deceased had two wills that were executed on the same day. One was termed the primary will and the other secondary will. Now, the primary will dealt with his personal assets and expressly excluded his interests in his privately held business and any money that was termed to be held on trust for him. Whereas the second will spoke to those exact items. It was his business interests and any money held in trust for him. Now, ultimately, Justice Greer decided that you could probate, you could have more than one will, and only one would be subject to probate because it is simply a matter of good planning to limit the amount of fees, probate fees, that an estate would have to pay. Essentially, this decision was largely based on Section 32 of the Estates Act, which allows for limited grants of probate, so granting probate for only certain assets. As well, he talks about traditionally not all assets are always subject to probate, as Jonathan was describing a house for inheritance through survivorship or a designated beneficiary to an RSP or some examples. And in this case, it was very much the fact that there was solid estate planning that went into this, because the primary will concerned about $3 million in assets, whereas the secondary will addressing business interests concerned a successful excavating company with nearly $25 million worth of assets. So a probate fee applied to that would be rather significant. But again, it ultimately came down to it should be allowed because there was a tradition of it, and it was simply just good estate planning.
Yeah, and and the fallout of that case was that things started to change. So our rules of civil procedure now changed. So, if you look in the rules of civil procedure now, when it talks about probate applications, it talks about getting a certificate of appointment of estate trustees for assets limited to the will. So if you have more than one will and you're only applying for probate on one will, you're only paying probate on that one will. Now, it can backfire. Okay, now it's really important to keep in mind that when you are applying for probate with respect to a will, you must pay probate fees on all assets that fall under that will, whether you needed probate or not on those particular assets. So, for example, if you have a one will, all right, and all your assets are governed by this one will, and let's say as part of your assets you have a house that doesn't need probate. If your estate trustee is required to apply for probate on your will, they will need to pay probate fees on that house, regardless of whether or not probate was required or not. Okay. So similarly, let's say you make two wills. All right. You make a general will and you make a will that only deals with your house that you think doesn't need probate and the shares of your private company that you think doesn't need probate. And let's say when you pass away, your estate trustee learns, oh, no, I do actually need probate to transfer the house. You are going to have to pay probate because you are going to have to probate that secondary will. You are going to have to pay probate fees on the house and all of those shares, even though the whole thing was set up to avoid that. So that's why sometimes you see more than two wills. You'll see different assets being governed by multiple wills. Now, that certainly increases the complexity. That certainly creates opportunity for problems to arise. You also have to keep in mind that the amount of legal fees that can accrue and the amount of complexities that can arise, you're doing this all to save 1.5%. So, I know that people like to rush out and do these complicated estate plannings, but let's keep in mind that the goal of avoiding probate fees sometimes doesn't justify the risks and the setup costs of all this. And that's also something to keep in mind. Any other risks that you can think of in terms of multiple wills?
Well, that's it. It's definitely that risk, degree of complexity that introduces that risk. And for sometimes it would only apply to certain assets like corporate interests, which might warrant those. So you definitely don't want to introduce complexity unnecessarily. There could also be interpretation issues. There was one case, Milnes, which excluded a certain number of assets, but it left up to the estate trustee to define the assets. And that was ultimately led to a whole slew of appeals and such, showing that kind of complexity.
Yeah.
So it has to be entered cautiously.
Mm-hmm. Yeah, no, I mean, I know there's a whole slew of cases about where the expenses get paid from. Let's say you have a primary and a secondary estate, they both have lots of money. Where do the expenses pay from? Where do the taxes get paid from? So those are things that you definitely have to keep in mind. The other thing that also has to be really kept front of mind when you're doing multiple wills is drafting to make sure that you don't revoke the first will that's signed on that day, right? Because most wills start, I hereby revoke all previous wills executed by me. right? That's the standard opening line of any will. You're revoking anything that came before. But if you're sitting down, you're signing multiple wills, and you sign one will at 10 o'clock and your second will at 10:05, you have to make sure that the one signed at 10:05 doesn't revoke the one you signed at 10 o'clock. And there are a whole slew of cases that deal with that unintentional revocation. So another thing that drafting lawyers have to keep in mind when you're dealing with the multiple will situation. Listen, we're surely not going to get into all the details and complexities of multiple wills, but I do think that it was a good idea to sort of have a bit of a refresher on what multiple wills are, how they can be used, how they can backfire. And, at the end of the day, you have to look at what tax am I trying to save and what are the risks and costs that I'm incurring in order to put that process in place. So, but I think that sort of concludes our podcast for today. Until next time, we want to thank you for listening. I'm Jonathan Cappy.
And I'm Daniel Boucher.
Should you have any questions, please email us at info@hullandhull.com or contact us through the contact page on our website. Have a great day.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.